Assalamualaikum Doctor and greetings to all my dear friends. We are from Team 6 for the subject MGM4321 Company Law. Today, we will be explaining on one of the most important topics in company law regarding directors' appointment and legal duties. Before that, let me introduce our correct team. These are our team members. We have Nur Hazira, Nur Iza Najwa, Muhammad Azmin, Nurul Huda, and Muhammad Daniel Din. Basically, companies have two main organs, namely Board of Directors and members. So, do you know who are the directors of a company? Directors are basically fiduciary agents and they owe duties to the company. Directors are appointed by the company shareholders to run the company's affairs for the benefits of the shareholders. According to the Section 196 of the Companies Act 2016, a company shall have a minimum number of directors, which is, in the case of private company, may have one director. Meanwhile, in the case of public company, should have at least two directors. And also, a director must be a natural person who is at least 18 years of age. In the company, there is a person that connects with the directors. Section 197 provides that a person shall be deemed to be connected with a director if the person is, first, a member of the director's family, second, a body corporate which is associated with the director, third, a trustee of a trust other than a trustee for an employee share scheme or pension scheme under which that directors or a member of the director's family is a beneficiary, and lastly, a partner of that director or a partner of a person connected with that director. Do you know that a company directors can be disqualified? A company directors can be disqualified as a director under Section 198 of the Companies Act 2016 when an undischarged bankrupt, next, has been convicted of an offence relating to the promotion, formation or management of a corporation, has been convicted of an offence under Section 213, 217, 218, 228 and 539 or has been disqualified by the court under Section 199.
Following to Sections 201 of Companies Act 2016, it provides that a person shall not be appointed as a director of a company unless he has consent in writing to be a director and make a declaration that he is not disqualified from being appointed or holding office as a director of a company under this Act.
Next, as stated earlier, every private company, including a newly incorporated company, must have at least one director, whereas for a public company, the minimum number of directors is two or more persons that must be appointed differently. According to Section 202, Subsection 1, a person named as the director in an application for incorporation of a company shall hold office as a director from the date of incorporation until that person ceases to hold office as a director in accordance with this Act. And by referring to Subsection 2, all subsequent directors of a company may be appointed by ordinary resolution.
Furthermore, acts done by a person as a director shall be valid. This can be referred to the Section 204 of Companies Act 2016, provided that the acts of a director or manager or secretary shall be valid, notwithstanding any defect that is discovered under his appointment or in his qualification.
The general power to manage the company is given to the Board of Directors, and this is codified in the Section 211 of Companies Act 2016, which in the subsection 1 provides that the business and affairs of a company shall be managed by or under the direction of the board. And in the subsection 2 provides that The board has all the powers necessary for managing and directing and supervising the management of the business and affairs of the company, subject to any modification, exception, or limitation contained in this act or in the constitution of the company.
Mona Villa Sharma is a company that set up by Plaintiff 1 and Defendant, which is Defendant 1 and Defendant 2. Defendant 1 handle marketing and cooking with Defendant 2, mostly follow instruction by Plaintiff 1. Plaintiff 1 is a managing director and chief executive officer for the defendant company and also the one who is running the business. Plaintiff claimed that she have given advance or loan to operate the defendant company. Tamayal branch is the branch of the defendant company that set up by plaintiff without obtaining any approval from the other two directors. Plaintiff claimed that she has told the other two directors about the opening of new branch at her birthday party. And she thinks that she has full authority to make a decision since the other director left everything to her to run the business. Defendant 1 known about the agreement with David, which is the investor that invests RM150,000 in Tamanya branch, with the new branch of Venda Villa. She admits that plaintiff have told Defendant 1 and Defendant 2 about the opening of the new branch, and Defendant 2 decided to call for an EGM, but was refused by the plaintiff number 5, which is the secretary of the defendant company. Because of she was not familiar with Defendant 2, as Defendant 2 was not really involved in the management of the defendant company. Then, plaintiff has resigned from the defendant company and claimed for the defendant to pay up the advance or loan that she have made for the defendant company. But Defendant 1 and Defendant 2 refused to pay back because there has no evidence for the payment that have been made. Because of that, plaintiff has decided to take the issue to the High Court to get her claim.
I have carried out my duties as managing director of this company and have made an advance or loan amounting to 1.5 million to run the business. Since both of you do not contribute any capital, I want to claim my money back, and I already recorded all the transactions that occurred in Bundle A, pages 68 until 223.
You cannot claim that money because most of the document that we received is no signs and date, and there are no resolutions since Linda Hu refused to issue an EGM, and no agreement related with David, and any kind of loan and advance made by you as evidence.
I already asked Liu Xiuyi, who is an outsourced accountant for this company, to put up a proper accounting based on the document that you have given. She said there is missing document to support the payment that have been made and the expenses that already been incurred. Counsel from both parties, plaintiff and defendant, giving their argument on the issue that has been raised.
My client, the plaintiff, has submitted documents such as bills, invoices, receipts, and bank slips as evidence for her claim toward the defendants in getting a return on her advances and loans for the defendant company.
It is true that the plaintiff provided several related documents as evidence, but the problem is that all of these documents are not verified and are not supported. The management project that was provided by the plaintiff has not been finalized and audited, so the draft cannot support all the claims that the plaintiff has made to my clients.
The draft management is prepared by Plaintiff 5, which is a secretary of the defendant company. She prepared the draft based on all documents that provided by the plaintiff. After they all resigned, the new secretary of the company found that the sum of the documents were not completed and not verified. Even Defendant 5, which is the outsourced accountant for the company, cannot produce a full report due to the messy of the document.
Moreover, there has been no board meeting that has been met for the time they operate the company, so there has been no resolution past the plaintiff to make any advance or loan to the defendants.
Because there has been no board meeting, so we should not make this resolution pass as an issue. Furthermore, the company is also unsure whether they are running their company in compliance with the law or not.
After all the argument between the counsel from the both parties about the claim that have been made by the plaintiff, High Court made a decision that plaintiff has no right to claim the advance or loan that she made to the defendant company as there is not enough proof.
The court is now in session. You may be seated. Firstly, the court determined that the plaintiff cannot provide supported evidence due to her claim. This is due to breach of one of the fundamental rules of evidence. Besides, the plaintiff also didn't include sufficient proof to show that she produced any advance funds for the company. Therefore, it is my judgment that the plaintiff has failed to discharge on the balance of probabilities that she has made advances to the defendant company. As I have alluded earlier, the defendant was a loosely run company without any proper board meetings and no resolution had been passed.
Yes, Your Honor. We admitted that we are not aware of the statutory requirements under the Companies Act.
Yes, Your Honor, me and Christine are also equally responsible as practically there was no compliance with the Companies Act.
In the case of the Taman Yal branch, I concluded that it was a branch of the defendant. Therefore, there was no issue as regards non-compliance in this respect too. Since the company let the plaintiff run the business, thus, there is no case of unjust enrichment. With regard to the rest of the expenses and losses incurred, no evidence was leaked and those documents were not even referred to. Based on the totality of the evidence, I dismiss both the plaintiff claim and the defendant's counterclaim. Therefore, both parties will need to bear their own costs.
We are now going to present the related act with the case based on Companies Act 2016. Next. In section 213, a director of a company shall at all times exercise his power in accordance with this act for a proper purpose and in good faith in the best interest of the company and exercise reasonable care, skill and diligence. This section emphasizing the acting of director beyond their powers. A director who contravenes this section commits an offence and can convicted. The director will be liable to imprisonment for a term not exceeding 5 years or fine not exceeding 3 million ringgit or both. From this case, plaintiff make a claim that she has made an advance or loan to the defendant company, but there has no resolution passed as there has no board meeting have been done. This means that plaintiff given the loan without the resolution authorizing on it. The plaintiff will be acting beyond her powers and will be guilty of a breach of fiduciary duties. Next. In section 214, provides that a director who make a business judgment is deemed to meet a requirement of his duty as a director if he make the business judgment for a proper purpose and in good faith, does not have a material personal interest in the subject matter of the business judgment. Third is informed about the subject matter of the business judgment to the extent to he reasonably believe that to be appropriate under the circumstance. Fourth, reasonably believe that the business judgment is in the best interest of the company. The board of directors who have been authorized by a resolution passed in a general meeting to approve a transaction may thereafter act in its best judgment in the interest of the company in the implementation of the resolution. But in this case, there has no board meeting had held. So it means there has no resolution passed for the board of directors to approve any transaction. Next. In section 215, director may have to rely on information provided by third party, which is first, an officer whom the director believes to be reliable and competent. Second, a professional or expert retained by the company. Third, another director.
Lastly, a committee to the board of director on which the director is not a member. However, in section 2152 state that when director relying on the information provided by others must still act in good faith and make independent assessment of the information based on director's knowledge. Based on the case where director, which is plaintiff, believe on her secretary in providing draft management on every record of transaction that she has made for the company. And the other director, which is defendant 1 and defendant 2, they check on all documents with the help of outsourced accountant and find out that all document that they receive is not verified and has missing document. Next. In section 216, the directors may delegate any power of the board to a committee, director, officer, employee, expert, unless such delegation is prohibited by the Company Act 2016, the company's constitution, board resolution, or members' resolution. Board of Directors that has delegated its powers is still responsible for the delegator's action, except if the director believes that the delegator will exercise the power in conformity with the duties imposed on the director and the delegator was reliable and competent. According to this case, defendants, which is defendant 1 and defendant 2, not fully exercise their power because plaintiff is the one that running the defendant company. So we can say that defendants delegate their power to the plaintiff and they also need responsible for the plaintiff action in running the business. Okay, next.
Section 219 is regarding Director's general duty to make disclosure. According to subsection 1, the directors of a company shall give notice in writing the company regarding, firstly, contracts necessary for the purpose of compliance with section 59, particulars of any change in respect for the particulars referred to in paragraph A, and such events and matters affecting to himself with the requirement of this act by company. Then according to subsection 4, the company shall send a copy of the notice to each of the other directors of the company within 7 days from receiving a notice under subsection 1. Lastly, according to subsection 7, a company which contravenes subsection commits an offence and liable to a fine not exceeding to 25,000 ringgit. In a case of continuing offence, he will then liable to a further fine of 1,000 ringgit for each day which the offence continues. Next slide. Section 224 is regarding loans to director. A company shall not enter into any guarantee in connection with a loan made to such a director by any person. It shall not authorize the making of any loan or the entering into any guarantee except with the prior approval of the company on the resolution in which the purpose of the expenditure. Besides, when the approval of the company is not required by any condition, the directors authorizing the making of the loan shall be jointly and severally liable to indemnify the company against any loss incurred. If a company contravenes this section, they will be liable to imprison for a term not exceeding 5 years or to a fine not exceeding 3 million or to both.
Okay, in continuance to section 225 regarding the prohibition of loans to persons connected with directors, this relates to section 224 where the company will subject to the provisions of the section other than an exempt private company shall not make a loan to any person connected with the director of the company or its holding company or enter into an agreement or provide any security in connection with a loan made to such person by any other person. For section 225 number 3, it states that nothing in this will prevent the company or person to recover the amount of any loan or amount for which it becomes liable under any guarantee, and if the company contravenes with this section, they are liable to imprisonment not exceeding 5 years and not exceeding or a fine not exceeding 3 million or both. This relates to the situation where the the defendant had the second defendant was given a loan by David instead of his investment. Moving on to section 228 regarding the transactions with directors, substantial shareholders, or connected persons. A company shall not enter or carry into effect any arrangement or transaction where a director or substantial shareholder or person connected will acquire or is to acquire the shares or non-cash assets of the requisite value from the company, or disposes of or is to dispose of shares or non-cash assets of the requisite value to the company. And if they commit an offence in contravention of the section, they are liable to imprisonment not exceeding 5 years, and or uh, they will get a fine of not exceeding 3 million or even both. And lastly, a reference to the acquisition or disposal of a non-cash asset includes the creation or extinction of an asset, estate or interest in, or a right over any property, and also the discharge of any person's liability other than liability for a liquidated sum. So this refers to the new branch where the plaintiff had opened without the information of the both of the defendants. And lastly, regarding section 229, which is an exception to section 228, section 228 shall not apply to an arrangement or transaction for an acquisition or disposal of a non-cash asset entered into by a company which is an acquisition or disposal of an asset in the ordinary course of business of the company and is on terms but not more favorable than those generally available to the public or employees of the company, or by a company if such arrangement or transaction does not involve transfer of cash or property, and which shall have no effect unless approved at the general meeting or by a relevant authority. Or lastly, they are informed about the subject matter of the business judgment to the extent that he reasonably believes to be appropriate under the circumstances. That is all the sections that are related to the case, and that is all from us. Thank you very much.